Hello, everyone. Welcome to our event this evening. I'll go ahead and get started with a few housekeeping notes and an intro. So before we begin, and in honor of Indigenous Peoples Day, I would like to acknowledge that Lawrence Public Library is situated upon land that was home to Indigenous peoples, primarily the Kaw, Delaware, Shawnee, and Osage nations, prior to settler colonialism. Let us all recognize the enduring presence, struggle, and resistance of those Indigenous peoples who live on this land. A few housekeeping notes. If you do have questions, please click on the Ask a Question text at the bottom of your screen. This is being recorded, and you can access the recording either here on Crowdcast or on YouTube, which I will get up on our channel by tomorrow. I'm very happy to welcome everyone to our keynote event in our Big Read, Read Across Lawrence series surrounding Louise Erdrich's The Roundhouse. This is a program affiliated with the NEA Big Read, and the NEA Big Read is a program of the National Endowment for the Arts designed to broaden our understanding of our world, our communities, and ourselves through the joy of sharing a good book. Lawrence Public Library is one of 78 not-for-profit organizations to receive a grant to host an NEA Big Read project between September of 2019 and December of 2020. The NEA presents NEA Big Read in partnership with Arts Midwest. I also want to thank all of our wonderful community partners, KU Libraries, Haskell Indian Nations University, Haskell-Tommy Library, the Lawrence Public Library Friends and Foundation, the Willow Domestic Violence Center, the Raven Bookstore, and the Spencer Museum of Art. We have several events planned for the next couple of weeks, and I'll throw up links to all of those in the chat. You can visit lplks.org/RAL for information on our upcoming book talks. At 7 p.m. on Thursday, we'll have Small Business Story Time with Leeway Franks, one of the few Indigenous-owned businesses in Lawrence, where we'll hear from co-owners Lee and Kay Weisel, who will share the story behind their business and their insights into navigating today's unique challenges. And then next Tuesday at 7 p.m., we'll have Bring Your Own Book Club with the Spencer Museum of Art, where we will discuss selected works in the Spencer's collection that resonate with the themes in the Roundhouse. We will get links up tomorrow, so please keep an eye out on our social media and website for those links to join. And then Wednesday at 7 p.m., we are hosting Rachel Louise Snyder in partnership with the Willow and Raven. Snyder will talk about her latest book, No Visible Bruises, an investigative look at the roots of intimate partner violence, its far-reaching consequences for society, and what it will take to truly address it. And now for the reason we're here tonight. Our guest tonight is a citizen of the Muscogee Creek Nation of Oklahoma and a distinguished professor at the University of Kansas. Her 2015 book, The Beginning and End of Rape, Confronting Sexual Violence in Native America, is the culmination of over 25 years of working with survivors and has received several awards, including the Best First Book Award from the Native American Indigenous Studies Association. A lawyer by training, but an advocate in practice, her scholarship focuses on the intersection of federal Indian law and victims' rights, using Indigenous feminist principles as a framework. She is a co-author of 4 textbooks on tribal law and has been published in a wide variety of law journals. Her work to end violence against Native women has received national awards from the American Bar Association and the Department of Justice. She has testified before Congress on 4 occasions regarding violence against Native women and was appointed by Attorney General Eric Holder to chair a federal advisory committee on sexual violence in Indian country. She was named a MacArthur Foundation Fellow in 2014, and in 2019, she was inducted into the National Women's Hall of Fame. She currently teaches at the University of Kansas, where she holds a joint appointment in Women, Gender, and Sexuality Studies and the School of Public Affairs and Administration. She is also the Chief Justice for the Prairie Island Indian Community Court of Appeals. I'm so honored to have you speak with us this evening. Please welcome Professor Sarah Deer.
Well, hi, everyone. It's very nice to be here from my home in West Hills and to join all of you this evening to talk about the Roundhouse. I'm not a literary scholar, and in fact, I must confess that I am not a fiction reader by and large. And I know that's probably not the best thing to say to a librarian group, but I wanted to say that only because this book, has had such a profound impact on my work. And in fact, it is so accurate in many ways that I actually assigned it to law students as part of their curriculum on federal Indian law, because it really articulates some of the challenges that tribal nations face in trying to respond to violent crime. So I'm really thrilled to be here tonight. There will be some spoilers, so if you don't like those and you have not yet read the novel, you might want to tune out. But I hope to share with you some of my own thinking about this book and what we can learn from it. So it's an honor to be asked to do this, and I'll start also by saying Happy Indigenous Peoples Day. So I have a short slide presentation that I'm going to share with you in a moment. And my understanding is that you can submit questions by clicking on Ask a Question, and we will leave time at the end for me to review some of your questions. So let's try here. Okay, is my screen showing?
Yes, it is.
Great. Well, I first heard about this book when I was still a law professor in Minnesota, and I was so excited to learn that the issues that I work on were going to be featured front and center in this incredible novel by one of the best writers of our generation, Louise Erdrich. As I've read it and I've compared it to my own practice of law, I have found so much synergy between the story that she tells here and the story of so many Native women whose stories don't get told. And so it's a very profound experience to read it and to talk about it as well. Now, I am not Ojibwe. I'm a Creek citizen, and our people are originally from the southeastern part of the United States and have a very different culture and heritage than Ojibwe people or Anishinaabe people. And so to the extent that I want to be cautious, it's only because I don't, there's sometimes a expectation that sort of, all Native people kind of have the same beliefs and systems, and they're quite diverse, in fact. So to the extent I'll be talking about Ojibwe culture, I'm speaking about it generally not as an Ojibwe scholar or person. But if you've never seen a roundhouse, and I don't think there's one in the book as a work of fiction, but this is just to give you an idea of kind of what we're talking about here. There's an older picture of a roundhouse, and then a more contemporary picture as to what these generally look like. So as you're trying to think about those images in the book. For me, and I'm speaking as a legal scholar, this book is about justice and different kinds and modes of justice. And that is the challenge that Native women face in this day and age, is how to achieve some semblance of justice for the harms that we experience. And I found that this passage, and I'll share several different passages from the novel as I go along. My page numbers are based on the paper book version that I have. I know there's been some different printings that may have different pagination, so I apologize for that, but I wanted to pull out some key concepts from the text itself. So I love this passage talking about any judge knows that there are many kinds of justice, ideal justice as opposed to the best we can do justice. And this particularly resonated with me because tribal nations today, and I can speak directly about my own tribe here, have struggled to provide what justice looks like, right? To be able to respond to crimes, to be able to respond to harm that's happened to our fellow citizens. We have a number of significant restrictions on our ability to do that. And I think that's really part of the story of the Roundhouse, is to tease out why that is and what kind of harm that it does. And so often judges are left with, you know, they would love to be able to do something or love to be able to address something, but the way the law and the legal system is set up, it makes it very, very difficult to take action in some of these cases. And that's a recurring theme in the Roundhouse. So I think that because today is also in some places known as Columbus Day, I wanted to start out with a quote that I'll have you take a look at. Now I will let you know that there is a graphic description here of a sexual assault, and to be mindful of folks that have a difficult time with this material. And I hope you'll reach out for help if you find yourself struggling with the novel, with my quote, or with any other aspect of this situation. So I'll read this quote here. "When I was in the boat, I captured a beautiful Carib woman. I conceived desire to take pleasure. I took a rope and thrashed her well, for which she raised such unheard screams that you would not have believed your ears. Finally, we came to an agreement in such a manner that I can tell you that she seemed to have been brought up in a school of harlots." Now, this paragraph describes very clearly to me a sexual assault with the physical violence and the restraint that was placed on this particular person. And I think it's important that we be honest about where this comes from. When was this written and who wrote it? It was from the journal of one of the passengers on Columbus's second journey to the quote-unquote New World. And this was one of his childhood friends, an aristocrat who accompanied Columbus on that second journey. So the reason that I want to start with that is because I think that part of the dynamic of sexual violence against Native people can be traced back to original contact, and to be very clear and honest about what that means. So as you see here in this quote, he hadn't even departed the boat yet. He saw a Carib woman from the boat and decided that at that point he would have the authority and wherewithal to assault her. And you can see from his writing here that there's no shame attached to this. It's an entitlement. It's an arrogance that he would be entitled to be violent to somebody in his journeys. And so, you know, in a sense is bragging about his conquest, I suppose. And so Columbus is a symbol, and that's why a lot of Indigenous people and allies have tried to change the discussion around this second week in October as an Indigenous Peoples Day, as opposed to celebrating someone who brought this level of violence and arrogance to the continent. And so I wanted to make sure that we started with that understanding that along with colonialism, along with bringing boats and people, there was also this assumption of power over land and bodies. And this has set the stage for what we have today, which is a true national emergency level crisis of violence perpetrated against Native women. And it's all part of the same story. And if we're going to be honest about, you know, what Columbus represents, it's not just the symbol of colonialism, but also the brute force and, you know, the pain that was inflicted on human beings from early contact and going forward. So I want to share with you a little bit of the data that we have that tells us more about this crisis. And I want to share with you, this is a chart from the most recent national criminal justice statistics that we have about violence against Native women. It is available for free online. It is called the Rosay Report, ROSAY. And you can find this report if you go to the website of the National Institute of Justice. So Google National Institute of Justice and then look for this report. You can download it for free. But I've just pulled out a couple of slides or a couple of images from that report to start our discussion. So this table represents violence against Native women. And I wanted to just highlight a couple of alarming statistics from this chart. So if we look here on anytime lifetime violence, this means the number of Native women in this study who reported that they have been victims of violence at some point during their life at over 84%. So the vast majority of Native women have experienced some form of violence. And then when we start talking about sexual violence, in particular, the kind of crime that we're looking at in the Roundhouse, we see again here this extremely elevated rate of 56.1% of Native women reporting that they have experienced some form of sexual violence. So well over half. And so the sad story is that the vast majority of Native women will experience violence in their lifetime. But we are not merely passive victims, right? That Native women are speaking out about these kinds of crimes and are developing systems of justice that address the unique needs that they've experienced. But it is important to note about this very high rate because it does tell us that, you know, we have an unacceptable situation, and the question then comes to us is what can we do to address it? And I hope to give you some thoughts on that as well. The other really interesting data in the American system is the rate of interracial perpetrators. This is really important both for the book and for reform on the ground. So most of the time in the United States, violent crime is characterized as being intraracial. And what I mean by that is if you're a white victim of a violent crime, statistically, it's much more likely that you've had a white perpetrator. And that goes for every other sort of racial category of people that we talk about in the United States. The main exception for that general principle is Native victims. And by and large, most Native victims report to the people doing the research that they've had at least one perpetrator who is non-Native. Okay, and again, that's quite unusual. And what this chart shows you here is another chart that I pulled from the report that I mentioned, the Rose report. And this takes a look at interracial and intraracial violence. So these top two bars represent the number of Native victims who report they've had at least one non-Native perpetrator. Okay, most Native people experience violence more than once in their lifetime. And some of that crime is committed by Native people and some of it's committed by non-Native people. But in terms of what Native women have reported, 97% report that they've been victimized by at least one non-Indian person, and 90% of Native men report the same. Now, this is not to say that Native people don't commit these crimes. They absolutely do. But that's represented here on the second two bars, where 35% of Native women report a Native perpetrator and 33% of Native men report a Native perpetrator. The other challenge with this kind of data is that it's national in scope, and it covers both on-reservation and off-reservation crimes. So there are certainly places in America where this data doesn't necessarily reflect the reality, because we've sort of taken all Native folks who've been victimized and kind of putting them in the same pot. So there's certainly going to be regional differences, even differences tribe to tribe as to who's committing these crimes and how that's playing out in the community. But this is what we have in terms of national data and the most recent data coming out of the US Department of Justice. When I started thinking about this issue, I was actually a student here in Lawrence. I got both of my undergraduate degree and my law degree here at KU. And when I was in law school, I had the opportunity to take federal Indian law, the first time I'd really had a chance to study the question. See, I grew up in Wichita, and my tribe is in Oklahoma. And I didn't grow up with a lot of connections with the tribe in Oklahoma. So I really didn't ever experience some of the challenges that tribal governments struggle with in the context of jurisdiction. And jurisdiction is just a legal term for power. You know, does the tribe have the power to do something? And because I grew up in a relatively urban setting, if Wichita is urban, I suppose urban for Kansas, but I didn't ever, have the misfortune of experiencing some of the complicated structures that exist on reservations. So it really wasn't until I was a law student and taking federal Indian law for the first time that I started to understand how the scheme of laws in Indian country actually perpetuates more violence. And so it was a big eye-opener to me, and I decided that I wanted to write my federal Indian law paper on domestic violence in my own tribe's history. And one of the things I was hoping to suss out is whether or not that the Creek people, the Muscogee people, my heritage, had how they had dealt with gender and violence, and whether it was an issue. Did we have 84% of Creek women experiencing violence traditionally? And of course, we will never really have the answer to that question because we weren't collecting data until well into the 20th century. But what I did discover gave me a lot of hope, because when I started researching the history of my tribe and gendered violence, I found a couple of really interesting things. And one of them came from this passage from William Bartram's journals. And Muscogee people were originally in the southeast. We're now in Oklahoma, but we were originally in the area that is now Georgia and Alabama. And we had a 1,000-year-old government, thousands of years old government at the time of contact. But Mr. Bartram was a white American. He was a naturalist. He was an eccentric character. He was an artist and a botanist, and he was sort of coming down to our area of the country to document plant and animal life and take journals and observations. I published a lot of those observations, and that's where I came across this passage, which is one of several where Mr. Bartram comments on the lack of gender violence that he sees among Creek and Cherokee people. So he was living down among the Creek people and the Cherokee people for a better part of a decade, doing his work as a documenter of life in the Southeast. And so he mentioned several times that he did not see the level of violence that he may have been accustomed to. In fact, he remarks that he never even saw a woman being disrespected by a Native person. And he remarked on this several times because, he comes from a culture, keep in mind, that is a very patriarchal culture, and one where essentially women are still the property of men under Anglo-American English common law, right? Women were not really individuals. We were property of fathers and then husbands. And so this was a remarkable kind of aspect of our culture to him, and he remarked upon it several times in his journals and writings. So as I started to learn more about Creek history and Creek law, I continued to do additional research, and I came across the next slide, which is our very first written rape law that we had as Muscogee people. Now, in 1824, there was still a lot of pressure being put on the Creek people to assimilate, become civilized, as the term was used, and sort of reject any trappings of things that might be seen as primitive or savage. We did a lot of the things that we needed to do to survive. And we were also very much intermarried with Scottish immigrants. And so we have a lot of McIntosh and McGirt and other Scottish surnames that are still very, very common among Muscogee people today. At any rate, part of that process was also to tell us as Indian people the way to run a government. Even though we had been doing just fine for hundreds and thousands of years, nonetheless, the expectation was that you will adopt trappings of sort of a Western law and order, Judeo-Christian principles and the like. So we were encouraged to write down our laws in English very early on, and this is one of the very earliest examples of a tribal law in the United States. Now, we didn't have a written language at this time. Our first real written language came in after removal in the 1840s and 1850s. So all of our laws were passed down orally, and they were held by specific prestigious members of the tribe to remember the laws and to recite them. But we were asked to codify them, and so one of the chief's sons, who was a clerk of the National Council, took it upon himself to take the Creek language oral decisions that had been made by his people and write them down in English so they could be given to folks that were scrutinizing us and trying to determine whether we should be really treated as a civilized people. So most of the laws that we wrote down in this time period in the 1820s were very similar to what you would have seen in state law, right? Because again, the idea is if you want to be treated as an equivalent civilized government, you will do what we do, right? You will copy our ways. But somehow, even though most of the laws do that, this particular law is very unique. And by that I mean it's a rape law. It's clearly about some form of gendered violence. And in fact, we didn't really have a real coherent word that we used for rape. So you see here that the English version is to force a woman, right? But the ending of this law, it's quite short, is what she say it be law. And I found that so profound when I first heard it, because it was not something you would have seen in state law at that time. In many ways, American or Anglo rape law was still very much couched in this idea of women as property. And the idea that a woman who cannot really even have the legal ability to testify would be able to articulate the punishment or to be able to be consulted about the punishment is really unheard of in American law at this time. So this clearly was some clue as to how things used to be handled, or potentially the philosophy that we use traditionally to respond to crimes like this. And it was a very inspirational moment. I was also serving at the time I wrote this paper as a rape crisis counselor for what is now the SAFE Center in Lawrence. And this was a profound moment as a young Creek scholar learning about these histories. So I think it's fair to say that, many tribes have stories like this about the low rates of domestic violence, the high esteem with which many tribal governments held women. We were not patriarchies in the sense that Europeans were. In fact, in many tribal nations, women had equivalent authority to men, or in some cases even a superior authority to men in some aspects of governance and politics. And so when this patriarchal system came to our shores, it was definitely a culture clash. And so we do see today that the Creek Nation and many other tribes are trying to sort of tap back into these traditional or pre-colonial principles and thinking about, what does that mean for us in the 21st century? But for me, as a Creek law student, it was a moment of real pride in knowing that I emanated from a culture where women were given, a status in the law and were able to articulate the harms that were done to them. But of course, things then kind of went south. And so I'll share a little bit about kind of what the next part of the journey looks like. So this is a passage from the book. This is from Joe, the narrator. He says to his father, "Which police?" I asked, and he responds, "Exactly." And this is part of the plot around jurisdiction and law as it begins there in the emergency room after the assault that takes place in this book. Jurisdiction is really just a word for power, right? Governments have power just by being governments. By virtue of being a government has power, right? But the challenge in Indian country has been that power has been curtailed. The ability of a tribe to respond in a timely way to violent crime is limited by federal law. And part of my work as an attorney and activist is designed to try to remove those barriers so that tribal nations once again will have the full power to respond to any crime that happens within the lands of that tribe. And that's really what my sort of political work has been around, is trying to change these barriers or eliminate these barriers as best we can. And there's been several laws and several different policies over time that have made it difficult for us to exercise jurisdiction. I'm just going to talk about a few of them, but that connect with some of the plot lines in the book. But I'm looking at things like the Major Crimes Act, the Indian Civil Rights Act, and a Supreme Court case called Oliphant versus Suquamish. So I'll talk about these in turn. So the structure in Indian country now is, if you're on a reservation, the default criminal justice system that's going to apply on that reservation is shared by two governments. It's shared by the tribal government, and it's shared with the federal government. Now, this is not the case everywhere. Kansas is one exception. But most of the time when there's a violent crime on a reservation, it's shared concurrently. That power to prosecute that crime is shared with the federal government and the tribal government. And it came from a law that was passed in 1885 called the Major Crimes Act. And the Major Crimes Act was a congressional law signed by the president that authorized, for the very first time, federal prosecutor authority on Indian lands. The backdrop of this case comes back to these two fellows you see on the screen here. On the left is Crow Dog, and on the right is Spotted Tail. And they were two Brule Lakota chiefs who didn't necessarily get along. In fact, I think it's fair to say they had a pretty long-standing feud. It's not exactly clear what the feud was about, because it depends sort of on which histories you're reading. But at the end of the day, the important part is that Crow Dog shot and killed Spotted Tail and committed a homicide on the lands that belonged to, that were reserved to the Lakota people. And Crow Dog was held accountable under Lakota law. So he was brought before his people, he was made to account for his actions, and he was sentenced, provided with his sanctions for this homicide. Well, the federal officials and the white folks in this area, this would have been in what is now South Dakota, were pretty upset that they saw Crow Dog walk and get a slap on the wrist for this homicide, and they didn't agree with it. And so they decided to prosecute him in federal court. And Crow Dog had a pretty good argument. He said, well, I'm not I have a nation, and the United States is essentially a foreign government. So where does a foreign government get the power to come in and prosecute? It'd be sort of like if France sent some people over tomorrow to start prosecuting crimes in Kansas. It just didn't make any sense. And he was victorious. He actually won his argument in front of the Supreme Court. It's a famous case called Ex parte Crow Dog. And the Supreme Court of the United States decided that Crow Dog's argument had merit, that indeed the United States was a foreign government to the tribe at this point, and therefore they lacked any kind of criminal authority. So Crow Dog was able to escape punishment from the white system, but the decision was very much disliked by many, many people on the ground. And they went to Congress and they said, give us the power. And that's exactly what Congress did. Congress passed a new law called the Major Crimes Act, which gives the federal government concurrent authority to prosecute felony crimes that happen on Indian reservations. This was not a request of the tribes. Tribes were not consulted in the drafting or the passing of the legislation. It was a unilateral effort to sort of control bad Indians by putting the federal prosecutors on the ground to take some of these cases into federal court. And that is still good law today. So the Major Crimes Act is still, in 2020, what the federal government uses to prosecute crimes in Indian country. Like I said, it does not apply here it's not used very often here in Kansas. In fact, some might say it doesn't apply. But for most tribes across the nation, this is still the criminal justice framework that's used in cases of homicide, rape, kidnapping, and the serious felony level crimes. So the problem with that comes in another passage from the Roundhouse, where she says if they're assigned to Indian country, they're either rookies or have trouble with authority. And this represents sort of a practical challenge that tribal nations have struggled with in terms of the federal government's role. The federal government has the power to investigate and prosecute violent crimes on Indian reservations. Do they do it? Historically, they have not done a great job. Now this is changing, and there's certainly been some very high-profile U.S. attorneys that have made it a priority, that have acknowledged the crisis of violence against Native people and have taken action. But that's really a recent development. So if you think about the Major Crimes Act was passed all the way back in 1885, it really wasn't until the early 2000s that I began to see federal prosecutors start to sort of take responsibility for their role. And so for many, many years and decades, in fact, what Native people will describe is reporting violent crimes and never hearing back, never getting a phone call, never getting any kind of anything from the federal law enforcement agencies that are tasked with protecting the reservation. And one of the things that we also learned, and I think this is why it's such a cogent theme in this passage, is that for many people who go into the FBI, right, and go into federal prosecution, had a very different job in mind that they aspired to, right? White collar crime, terrorism, major drug trafficking rings from Mexico, the big federal white collar and very, very international sort of flavor to the crimes that are committed in that kind of setting. And so many assistant U.S. attorneys or FBI agents who were assigned to Indian country initially were very not necessarily happy, because they did not see their career headed towards investigating and prosecuting a domestic violence case. They wanted to take down Enron. And so there was almost this cultural challenge within the federal judicial or federal law enforcement response to crimes in Indian country, that it just didn't become a priority. And keep in mind that sometimes federal courthouses can be 3 or 4 hours drive one way from where the crime actually happened on a reservation. So it was just, long distances and not connected to the communities. And we saw very few of these crimes prosecuted in the federal system. And in fact, we did hear stories about, people in the FBI who may have had some disciplinary issues, that they were let back to go back to active duty, but they were sent to Indian country. And so we didn't get the best of the Federal Bureau. And like I said, that has changed somewhat, but it is a legacy that I think we continue to struggle with. This is also connected to the FBI. So I just mentioned about federal declinations. The problem with most Indian rape cases was that even after there was an indictment, the U.S. attorney often declined to take the case to trial for one reason or the other, usually a raft of bigger cases. My father wanted to make sure that didn't happen. That's absolutely, again, and we do have now, for the first time, starting in around 2008, we were able to pass legislation that requires each district, federal district, that has Indian country to release the declination rates. And by that I mean we learn about a case, but we decide to decline to prosecute it. Prosecutors have discretion. Prosecutors don't have to prosecute every case that comes to their desk, and so they make decisions about which cases to prosecute and which to not prosecute. And in fact, it still is the case that almost 2/3 in some cases of sexual violent cases against adults and children are declined to be prosecuted by our U.S. attorneys. And there may be some good reasons for that. Evidence collection has sometimes been challenging, and there's other sort of witness, sometimes the U.S. attorneys will say we couldn't, the witnesses didn't seem very, enthused about testifying about the things they saw. But whatever the reasons are, most of the rapes that are reported to the U.S. attorneys that make it to their attention are not prosecuted. Now, the tribe would have the ability to prosecute, but as I'll discuss next, there's some limitations there as well. The other theme, I think, throughout the Roundhouse, which is important from the legal standpoint, is the need to know exactly where the crime occurred, right? Because in Indian country, it could be that if the crime occurred on my front yard, It could be a different government that prosecutes it if it happened across the street in my neighbor's yard, because Indian country is really carved out these what we call checkerboard reservations, where one might have one government on one side of the road and another government on the other side of the road. And so the story about what happens to Geraldine in the Roundhouse is very much, that becomes a very crucial question about determining where the crime even happened. And for a traumatized survivor, somebody who's been through a trauma like a sexual assault, may have difficulty remembering exactly where the crime occurred, especially if they were intoxicated or drugged or had a blindfold on. And that makes prosecuting these cases very, very difficult. This is an example of what I mean by a checkerboard reservation. This is actually the Cheyenne River Sioux tribe in South Dakota, and you can see there really is literally a checkerboard of different kinds of land. And as I said, it may depend on exactly which square you're on as to who's going to have authority in the case. So when we don't know where exactly the plot where Geraldine experienced that trauma, it becomes very difficult to prosecute that crime. Now, just a couple other points about tribal authority, because ideally, in my mind, as a Creek citizen and somebody who cares about crimes against women and children, I'm particularly concerned about the ability of tribes to be able to prosecute these cases. We can't control what the federal government does. That's not something that tribes can truly control. What we can control as sovereign nations is the ability to prosecute cases in our own courts, in our own criminal justice system. That's something that we have control over. But there's these limitations. For example, tribal nations, or I should say tribal judges, cannot sentence anyone to more than 1 year per offense, maximum. That would include homicide. It would include rape. It would include child sexual abuse, the maximum penalty. And that comes from Congress. Congress decided that we should not have the same sentencing authority that a state or the federal government might have. I think this is a huge barrier, because if you're a victim of a violent trauma, you're trying to make the very difficult decision about whether to come forward, whether to tell, to report. But you know that the maximum penalty that could be imposed is 1 year. That may change your comfort level about coming forward, right? So I think that's a big factor when we look at the limitations on tribal authority. We also know from the Roundhouse that there are perpetrators of all races that commit these crimes on Indian reservations, but that the tribal courts do not have authority over non-Indian perpetrators, again, no matter what the crime is. So a lot of my activism and scholarship has been focused on this particular question of why shouldn't the tribe be able to prosecute anyone on the land who commits a crime? Why does it matter what race they are? Well, the reason it matters is because there was a Supreme Court case back in 1978 about a small tribe in Washington state called the Suquamish tribe. And that tribe was exercising criminal authority over non-Indians. In fact, Mr. Oliphant and his it wasn't a gendered violence case, but one of them punched a tribal police officer in the face, and the other one led the police on a short but kind of high-speed chase that thankfully only ended in some property damage. But at any rate, they were prosecuted. And they argued that they should not be held accountable in tribal court because they're non-native. And they said it wasn't fair because they did not vote in Suquamish elections or sit on Suquamish juries. And so therefore it would be unfair for them to be prosecuted by the tribe. And in fact, they won that case in the US Supreme Court in 1978, a case called Oliphant versus Suquamish. Now, the other challenge here is that when the Supreme Court of the United States makes a decision about one tribal nation, it almost automatically is going to be the rule for all tribal nations. Now, Oliphant's argument would be sort of ludicrous if you think about it, in other contexts. So I'm sitting in Lawrence tonight. If I went to Missouri, to Kansas City, Missouri tonight, and I robbed a liquor store, and I was brought before the Missouri court systems tomorrow and said, I'm not from Missouri, I don't live here, I don't vote here, I don't sit on juries here, they're still going to prosecute me, right? That's not an out. So the fact that it worked for Oliphant is distressing, right? Why is there this exception? But when you think about this Supreme Court case, and you think about the fact that most Native people report having at least one non-Native perpetrator, right? You have to wonder if it's connected to Oliphant and the decision, and whether or not non-Indian offenders know that this is indeed the law. And I have talked to many tribal police officers over the years who've said, yeah, there is a certain criminal element, a predatory element of people that have some idea that tribes are a place where it might be easier to get away with committing these kinds of crimes. And so this has to be addressed by Congress. In fact, even in the decision, it said that Congress would have the power to correct this. And that's one of the things that I've been working on in my capacity as a scholar and an activist. So we have had some changes since the Roundhouse was published, and since some of my work has been published. We've had two major adjustments in the law. One of them came in 2010 with the Tribal Law and Order Act, and what this law did, in addition to many other things, is it did increase the sentencing cap from 1 year to 3 years. So tribes, if they choose to incarcerate, have more time that they can impose for incarceration. So that was one step in that direction. And then when the Violence Against Women Act was reauthorized in 2013, we did get a slight adjustment to that Oliphant rule that says tribes can't prosecute non-Indians. So the exception that we now have in the law, thanks to this effort, is that if it is domestic violence, in other words, if it's an intimate partner or a former intimate partner, the tribe has the option of prosecuting that non-Indian, but it's only for those limited cases where there's an intimate relationship between the perpetrator and the victim. So in Geraldine's case, this also would not apply. The tribe would still lack jurisdiction due to the non-Indian offender because it's not an intimate relationship. It's a stranger or maybe a long-term acquaintance case that would still not be prosecutable by the tribe under today's law. We've also continued to make arguments in the U.S. Supreme Court on other cases about violence against women and children and tribal authority to respond to those crimes. So there's sort of these efforts in Congress and also efforts in the United States Supreme Court to address these great injustices that Native people are experiencing. So thank you again for the opportunity to share with you some of my thoughts about the Roundhouse and the real story behind the Roundhouse. You can reach me at KU. Let's see how we do that. And I do have a lot of my publications posted at my website, which I feel a little ego trip to create, but I get a lot of requests. Yeah. So if you go to theaterbeer.com, you can download a lot of my articles about these issues. So thank you. I look forward to taking some questions.
So we got a first question from Hannah. Does the limitation of 3 years make retaliation a fairly big issue?
Yes, thank you for that. Yes, so the story of the sentencing limitations is interesting because it started out originally when Congress passed the law in 1968. It was actually limited to 6 months. Then under the Reagan administration, it was expanded to 1 year. And then under the Obama administration, it expanded to 3 years. And I can just tell you firsthand that while we know, I think, just in general, that incarceration does not solve crime, I think that that's becoming more clear in the larger conversation about penal systems. Definitely there are survivors who felt that if they came forward and the maximum penalty would be 6 months, 1 year, 3 years, that those perpetrators would be coming back to the community fairly quickly, and that knowledge did play a role in a survivor's decision to not report, because it actually could amplify the danger that they experience if the perpetrator is not provided therapeutic services and can come back sometimes worse than they went in. So absolutely, thank you for that.
Yeah, if anyone else has a question, please utilize that ask a question button. I have one. You mentioned, kind of the checkerboard of, kind of sovereignty. Like, how do local, like tribal law enforcement, do they have a relationship with local law enforcement or federal law enforcement, or do you see trends in relationships or them working together? I was just curious if they work together or if there's some hostility there.
Well, yes and no. And that's one of the challenges of talking about these issues, is that the relationships between federal, state, and tribal partners can work really, really well in some contexts. And there's a lot of crossover and a lot of cross-deputization. In other places, the relationships are much more difficult and fraught. And so it really depends, again, on sort of what reservation you're on and what kind of relationships have been developed. So for example, my tribe, the Muscogee Creek Nation, we recently we won a big Supreme Court case in July, and the court ruled that our reservation in Oklahoma is still in existence, although Oklahoma had said otherwise. So it was a big victory. And within our reservation that's now restored, or at least re-recognized, we share jurisdiction with multiple entities. And in fact, our own tribal police officers are cross-deputized with over 50 other entities, including counties and municipalities throughout the reservation. So we can essentially enforce their laws and they can enforce our laws. And we can also serve as backup to one another. So if it works well, but it's not always the case. There may be some bad history, bad feelings on both sides that can get in the way of those kinds of relationships.
All right, thank you. We have another question from Diana. What is the best way for those of us who do not practice in this area to support these efforts at legal reform?
I'm so glad you asked that question. Yes, so there are a number of things going on right now. In fact, 2 laws that deal with crimes on Indian reservations were actually signed into law on Saturday, believe it or not. And so there's 2 new pieces of legislation that I was going to encourage you all to support, but they are now federal law. And one is called Savannah's Act, and the other is called the Not Invisible Act. And they are both pieces of federal law that will require better and more coherent coordination between federal, state, and tribal authorities when it comes to violent crime. But in general, one of the vehicles with which many of us try to work through is the Violence Against Women Act, which was originally passed all the way back in 1994, when it was also known as the Biden-Hatch Act. And if you know anything about Joe Biden and Orrin Hatch, they are unlikely to agree on much, but they created the Violence Against Women Act in 1994. So what tribal advocates have tried to do is, when VAWA is up for reauthorization, which is about every 5 years, we go back and we try to put new provisions in to address the additional gaps that we've discovered on the ground. And so it was through that vehicle of the 2013 reauthorization that we were able to get jurisdiction over non-Indian domestic violence offenders back. The current VAWA is in limbo. So we had a version of VAWA in 2019 that passed the House, and we hit a stalemate in the Senate. So there's actually 2 versions of VAWA in the Senate, the Feinstein bill and the Ernst bill. And we strongly support the Feinstein bill, which matches the House VAWA because it includes restored jurisdiction over non-Indians who commit acts of sexual violence. So basically, the Geraldine story would then be able to be prosecuted by the tribe. But that is a very controversial provision, and so no movement has been made on VAWA since that stalemate erupted. And of course, we had other national crises that have come up in 2020, so it hasn't been at the top of the list. But if you were going to support the Violence Against Women Act reauthorization and contact your lawmakers, that Democratic version does include the fix that we're looking for with regard to sexual violence.
All right, and I think we'll do one more question from Deanne. Even though it's not the focus of your work, have you developed ideas about how to prevent the violence against women to begin with?
That's really the best place to start, right? You know, if we didn't have to respond to violence, then the jurisdictional structures would not come into play at all because we wouldn't need it. And so I'm not somebody that works directly on prevention efforts, but one of the most exciting things that I've seen developed out in Indian country are tribal nations that are sort of reteaching what it means to be Indigenous, right? That being Indigenous and being Native does not mean being violent to one another. That there are certain protocols and expectations for behavior that if we adhered to, we would see again, like William Bartram did among my people, saw very little disrespect for women being articulated. Where I come in is really trying to say, okay, if we're doing prevention work and we're telling young people, you know, that violence is not an appropriate way to respond to dispute, but we're also not holding adults accountable for those same crimes, it sends a mixed message to maybe the audience who's looking around their culture and saying, yeah, but you know, he was never prosecuted, so you're telling me it's wrong, but there's no accountability. So I see intervention and prevention as being very connected, very closely. But I'm glad you raised the issue because, yes, I think there are good programs out in Indian country to try to address these problems before they even become problems.
All right. Well, I think that's the time we have for this evening. Thank you so much for being our keynote for our Read Across Lawrence, all of our Read Across Lawrence programming. It's much appreciated, and I'm always, you know, astounded that we have people like you in our community. You do such amazing work. So thank you so much. And if you want to see other Read Across Lawrence events, please visit our website, lplks.org/RAL, and do visit Sarah Deer's website to see her work, sarahdeer.com. So thank you so much, and we'll go ahead and end for tonight. Thanks.
Thank you so much.
All right, bye.
Bye.